Eviction laws in Utah confusing you? Let's fix that. Welcome back, it's Galena with DoorLoop. Today, we will be diving into the eviction process in Utah. It may vary from county to county, but for the most part, it's the same general eviction process. Send a clear written eviction notice, fill out the forms, serve the documents, attend the trial, and wait for judgment. Every eviction process is different and dependent on the lease or rental agreement signed by both parties. This video is a summary for landlords to refer to when evicting a tenant. Remember, if you have any specific questions, don't hesitate to contact an attorney. Get our guide to eviction laws on the go from DoorLoop's Landlords Guide series. Click the link in the description. Now, let's jump in. Eviction reasons. Non-payment of rent. Landlords can evict the tenant for failing to pay rent in Utah State. Paying rent before being evicted usually stops the eviction process. Rent is usually considered late a day past its due. A grace period may be available if stated in a lease or rental agreement. Before they can start the eviction process, landlords must give the tenant an official written 3-day notice to pay. If the tenant wants to avoid eviction, they have to pay rent. Should they fail to pay the rent due and remain in the property after 3 days, landlords may continue with the eviction process. Violation of the lease or rental agreement. A tenant can be evicted for violating the terms of the lease. The rental agreement must be upheld by both tenant and landlord for the entire duration of their stay. If a tenant violates any terms of the lease, the landlord must issue a 3-day notice to comply. This notice to comply gives the tenant the chance to reverse the lease violation and remain on the property. Violations may include damage to the rental unit, subleasing the rental unit, smoking in non-smoking areas, and keeping pets in pet-free properties, etc. If the tenant remains on the property by the end of the 3 days and the violation is still present, then the landlord may continue with the eviction. Conducting illegal activity. The law in Utah states that if a tenant has engaged in illegal behavior within the property, landlords must provide an official written eviction notice called a 3-day notice to quit. There are 3 categories under this reason for the eviction: illegal activity, nuisances, and criminal activity. Examples of illegal activities are, but are not limited to, theft, violence, assault, running an illegal business, and committing a crime within the rental premises. Examples of nuisances are, but are not limited to, prostitution, possession and or firing of an illegal firearm, and involvement in the creation, distribution, or consumption of a controlled substance. Examples of criminal activity are, but are not limited to, committing a felony, engaging in activity involving a criminal gang, damaging the property of other tenants and or the landlord, and threatening violence against other tenants and the landlord. Committing waste. According to Utah law, waste is defined as the harmful destruction of property. In this case, tenants are usually not allowed to renew their lease. The landlord must issue a 3-day notice to quit. They must leave the premises before the end of the notice period to avoid eviction. Should the tenant remain on the rental property after 3 days, the landlord may proceed with the filing for eviction action. Non-renewal of the lease after the rental period ends. In Utah, landlords cannot evict a tenant or force them to vacate the property without probable cause. As long as they don't violate any rules, they can stay until their rental period ends. But if they stay in the property even a day after their lease ends and have not arranged for renewal, landlords must provide a written notice to move. The most common tenancy is month to month. To download your Utah lease agreement, visit DoorLoop's forms page by clicking the link in the description. Filing a complaint. How to file a complaint. The eviction process in Utah provides the landlord with 2 choices when proceeding with eviction action. The process for each option is: option number 1. The complaint is filed to the district court first, then served to the tenant. This option gives the landlord a time frame of 4 months to serve the summons and complaint from the date they filed the complaint to the court. Option number 2. The summons and complaint is served to the tenant first, then filed to the court. This option gives the landlord a time frame of 10 days to file the summons and complaint to the court once they serve a copy of the documents to the tenant. Timeline. It takes about 3 to 15 days from the issuance of notice to pay or quit before a landlord can proceed with the official eviction action should the landlord choose option 1. If the landlord chooses option number 2, then they have a 10-day time period to file the documents to the court. Serving the tenant. How to serve a tenant. Utah law states that anyone over the age of 18 and is uninvolved with the case delivers the court order, also known as the summons, for the eviction hearing and the complaint to the tenant. This is the next step in the Utah eviction process. There are several methods available. Personal service. The summons and complaint is served to the tenant in person. Substituted service. If the tenant is unavailable, a copy of the documents may be left to someone residing with them who is of a suitable age. Mailing. The server mails the documents but must request a return receipt. After serving the summons and complaint, a tenant must file a written answer in court should they wish to dispute the claims of the eviction hearing. They have to give the answer within 3 days from the date they receive the summons. If they are unable to give a written answer before the deadline, they can request more time, but approval of this request is not guaranteed. If they fail to provide a written answer, then the judicial officer will issue a judgment in favor of the landlord without the need for an eviction hearing. Timeline. A landlord who has chosen option number 1 will have about 4 months to serve the documents. The timeline for option number 2 is 3 to 15 days, depending on the notice period. Make sure to visit DoorLoop's complete guide to Utah's landlord-tenant laws for more information. Notice to comply. Before filing for an eviction with the court, you need to issue the tenant a notice to comply. You can either download the free PDF or Word template or create your Utah eviction notice by clicking the link in the description to use a step-by-step wizard that guides you through the entire process to make sure you are submitting the legally correct notice. Keep in mind, the step-by-step wizard will ask you to pay a small fee at the end. It's a small price to pay to ensure legal compliance and protection. The last thing you want is to go to court only to find out you did the first process incorrectly. Asking for possession. Filing a motion to obtain judgment and get a judgment for possession. The landlord has to provide a strong argument and use solid evidence against the defendant. This could include, but is not limited to, the following: copy of the deed and lease, rent receipts, rent ledgers, bank statements, witnesses, and photo and video documentation of notices, correspondence, etc. Should the tenant fail to show up to the hearing, the landlord wins by default. Either party has 10 days to appeal the judgment, but if the eviction case was due to illegal activity and/or nuisances, they only have 3 days to file for an appeal. Next procedure if the tenant disagreed and replied. In accordance with the Utah law, a reply from the tenant is necessary for an occupancy evidentiary hearing to be scheduled. An occupancy hearing decides if the tenant can remain on the rental property before proceeding to the next step. An evidentiary hearing has to be held within 10 days after a written answer is filed. In some cases, the court may decide to rule in favor of the landlord, negating the need for a second hearing. However, if the judicial officer decides that a second hearing is necessary, then it is scheduled within 2 months from the time the landlord first filed the complaint to the court. Getting possession of the property. Provided that the tenant does not appeal for a reconsideration, an order from the restitution is issued immediately after judgment is passed in favor of the landlord. The order for restitution gives the tenant a maximum of 3 days to vacate the property from the day it was served. Move out process. Before possession of the property is returned to the landlord, Utah eviction law dictates that the tenant has 3 days to move out from the rental unit. However, if the reason for eviction involved illegal activity, the tenant is removed from the property immediately. Only the sheriff or the appropriate authorities are allowed to evict the tenant by force. Even if the landlord wins the case, they are not free to engage in legal methods of eviction. The state of Utah does not specify what to do with a tenant's belongings. If any belongings are left behind, landlords are advised to contact the tenant and give them a reasonable time frame to claim them. After the time frame has passed, the tenant's property may be sold or disposed of. Utah eviction process timeline. On average, it would take anywhere between 1 to 4 months for a complete eviction process. This does not include the extra time it will take when either party files for an appeal or continuance. Showing evidence. How to keep good records. If the tenant disagrees with the eviction request and they reply to the court, it's important that you keep extremely good records of everything so you can provide proof to the judge and win your case. This part can make or break your entire eviction request in the event of a dispute. You can stay organized by keeping a physical paper trail. This gets very hard to search through, takes up a lot of storage space, and could get lost, damaged, stolen, or burnt in a fire. Scanning documents. Scan every document into your computer. Backups. Store and backup every file using Dropbox, Google Drive, OneDrive, or any other software that can make the documents easily and safely accessible. PMS. Use a property management software to save everything from lease agreements, signed documents, violations, emails, notes, invoices, payments, reminders, maintenance requests, pictures, videos, and anything else that can possibly be useful in a court case. This is used best when you also scan every document into your software. Evidence to show for not paying rent. If the tenant does not pay rent and they dispute that claim, it's important that you show the judge the following: your lease agreement, showing the terms of the agreement, when rent is due, and any penalties for late payment. All payments, showing all previous payments, how they were normally made, check, credit card, ACH, etc., and what date they were normally paid on. Any payment returns. If their check bounced, their bank account had insufficient funds, or they did a chargeback dispute on their credit card, show this to the judge. Also, show any fees your bank may have charged you and any penalties you are owed according to your lease agreement. All messages. If you set your tenant automated or manual payment reminders by text, email, letter, or mail, it's important to show this. While it's usually not needed, it is still important to show that the tenant did actually violate the terms expressed in the agreement. This is why it's always best to have everything in writing instead of any phone calls or face-to-face meetings. Evidence to show for lease violations. If you're evicting the tenant for lease violations, for example, noise complaints, unauthorized pets, or property damages, it's important to show proof from any of the following methods. Security cameras. If you have a surveillance system that can show them committing the crime or lease violation, it's safe to say you will normally win this dispute. Video. If you don't catch them in the act, the next best thing is to record a video with your phone of any damages of the lease violation. Pictures. They say a picture's worth 1,000 words. In this case, a picture could be worth thousands of dollars. Even if you take a video, it's important to show the judge any pictures too, as it's usually easier to see by email or printed. Lease terms. Once again, show the court which term they violated in their lease agreement. The violation does not necessarily have to be specifically listed in the terms every time. If the violation is bad enough, it might not be needed to have it written. As a good practice though, start adding all of the potential reasons to evict a tenant into your agreement. Before I go on to talk about self-help evictions, don't forget to like, comment, and subscribe for more amazing content. Self-help evictions. Examples of illegal self-help evictions include changing the lock, taking the tenant's belongings, removing the front door, or turning off the heat or electricity. Many states specify how much money a tenant can sue for if the landlord has tried to illegally evict the tenant through some sort of self-help measure. Some states also provide for a tenant's court costs and attorney's fees if the tenant successfully sues the landlord, and or give the tenant the right to stay in the rental unit. And that's it. Thank you for watching this video. For more valuable content, join our exclusive Facebook community with the link in the description. And to learn more, feel free to check out these videos. Thank you and have an amazing day.